Mr. Stansberry, what you're formally charged with is obviously the first-degree felony offensive murder. And that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions.
Nothing, as far as you know, not waiting on any type of discovery or
I
evidence?
think there's
Got it all.
nothing that's standing out that
Okay.
is going to delay.
All right, so I want to make sure you understand also, Mr. Stansberry, that after today, I will not accept this agreement. The only reason I would accept this or something different or better would be because some different evidence or information came to light that your attorney and the state's attorney didn't know at this point. You understand? All right, we'll get it set on the trial docket. Mr. Burbank will be in preparation for trial.
I think that's it.
Yes, sir. Thank you.
Excellent.
Mr. Lewis, you have Brandon Bonton.
Yes, ma'am.
Brandon. Think we've got 1, 2, 3, 4, 6 cases. Good morning. Did I miss a whole page? I did. There we go. 1, 2, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I've received that report. I'm going to take judicial notice of the court's file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the state, Your Honor.
At this time, then, I am going to find that Mr. Bonton is not competent to
Can I-
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Freemason Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of tick tests. I'm innocent.
All
I
right.
got the right to freedom of speech, man.
So-
I'm asking for probation, 2-year cap. So
All
I can go home today because these people on the
That's not-
Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one doorway.
So,
Cameras,
Mr.
defended
Bonton,
himself.
you can
Jeremy
go
Daly shot that 45.
Go
Him
back
got
with the
that clip.
bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make
Sacrifice him, man.
that inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility.
No.
It's a lot.
Y'all should have went back.
All right, let's see. Mr. Eckhart, you've got Mark Marceau,
You judge.
3 cases. Good morning.
Morning, Judge.
I think that needs to become a full case.
Right, I'm gonna do it the right way. Very hard. Hey, can I go with my stuff, man? If they rather be murderers than rapists, go like, don't keep their pace, bro. But a brother, you know, fucking nigga talk. Right. Y'all gotta do your work, right?
Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau's charged in two of the cases with sexual assault of a child, and the third with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the two kind of most urgent matters that we've got.
Okay. I don't see that request has been made yet for the CPS records.
And not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that.
Okay.
Motion and order, Your Honor, and also, whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. And then we'll see where we are, but we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff.
If you want to look at the video this week, it's a.
Let's see, Mr. Brian Lane,
Yes, ma'am.
you've got Khalil Bradley Harris.
Yes, ma'am, that'll be a please.
I'll hold it till the paperwork's ready. And then what about Heyman Brandon?
If we may approach on him just for a second. Your Honor, the court allowed me some time.
Let's get Mr. Brandon out here. So he's Heyman Brandon. Yeah, just hold on a second, since he's here,
Okay.
let him know what's going on. All right, you're Heyman Brandon. And this is 21-36605. Mr. Brandon is charged with murder, and what is the announcement?
Your Honor, we're respectfully requesting one more announcement. The court has reset it today for us to get an insanity evaluation from Dr. Capone. It took me a little while to get to Dr. Capone. I spoke with him yesterday. He said if I'll get him the materials, he could have an evaluation report done within 2 weeks. So if we could just have one more 30 days, I believe that's going to.
My concern is deterioration in our jail because we finally have competency after years of not.
Right.
And so I need that done. This is, I'm going to reset it 3 weeks. We need to have it done within 3 weeks. And so.
I may be on vacation until the 15th, so.
Do you have a vacation letter in?
Yes.
Okay, we'll take that into consideration.
Okay, also, respectfully, if we get the report, I think the state's gonna look at it. If the state wants to move forward, then we're going to ask for a bench trial. We want to set that.
Well, let's see what the report says so that we know which direction we're headed once we get that report.
Oh,
So we'll just set it for an announcement and then that day we'll know for sure what we're doing one way or the other.
Just-
Okay, sounds good. You can go back with the bailiff. Mr. Lewis? Uh, Mr. Parker, you've got Donald Cogdale's of sentencing.
Parker.
We need to
Donald Cogdale. Cogdale.
You go back for a minute.
Hi, the people. Hi, please.
No, I heard it.
Good morning.
Good morning.
You are Donald Cogdale,
Yes, ma'am.
and this is 26 DCCR 0005. Mr. Cogdale was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino,
I have, Judge.
any additions or corrections?
None, Your Honor.
Judge, obviously, I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony. And the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate, if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
Said something about parole, not parole, but like, I don't know, I don't understand what he was saying.
Okay, there's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house. And I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen. And the facts are that he was out. It started pouring down rain. He went to a house. He was on a back porch that he thought was vacant, and he was on the porch getting out of the rain. And 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up and I got scared." And I mean, I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house. And that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for a low on the lower end.
Smallfino?
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Jonathan, Richard or Richard, Mr. Parker.
Let's see.
Jonathan Richard. John.
That case is a hard one for me.
Yeah, same, but
I agree with this.
Oh. Yeah. It's not my fault.
You put it says on reset. It's a competency. Here.
Yeah.
I don't, I mean, it's.
Jonathan Richard, that's yours, Ms. Malfino, from what I show.
That's weird. Mine shows paying French.
Oh. Oh, well, I don't know whose it is.
That's weird. How are you? West Preston's. There you go.
All right, so are you Jonathan Richard?
Yes, ma'am.
This is cause number 25, DCCR 0248. Mr. Richard was charged previously with evading arrest or detention with previous convictions and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Richard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again, with the finding that he is not competent to stand trial at the present time. Also, there is a physician certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and a result of that, they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding, that Mr. Richard is still not competent to stand trial and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None from the defense, Judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Richard is still not competent to stand trial, that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Richard, for a period of not to exceed 1 year to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably
Should expire while he's in.
So we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
Okay, I'll email.
All right, you can go back with the bailiff.
Thank you, Judge.
Mr. Rojas, you've got Manuel Cardenas.
No, it was 12.
Okay. We're gonna reset Sarah Jordan.
Jordan.
Mm-hmm.
And also, Judge, we're gonna ask to reset Mr. Pugh, Willie Pugh.
Okay. What's up with that one?
Ashley was gonna.
I just haven't been able to reach the officer yet, Judge. Sorry, just 1 week would be.
Yeah, we can be fine.
To ratify off of.
Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And I'm going to take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Brimsley, prepared a report and evaluated him. I've received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
There.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
All right, Mr. Cardenas, in cause number 26 DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation. And then we'll come back later for sentencing. And it looks like the state's already, you're opposed to a bond.
I am, Judge, just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's.
All right, we'll see you back at sentencing. You can go back with the bailiff. Kelvin Johnson, Mr. Rojas, it's a sentencing.
Kelvin Johnson. Kelvin Johnson. All right.
Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions, entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from state.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors anyway are trespassing cases. And I would guess, and Mr. Johnson tells me this is a case that most of those, because he was homeless, didn't have any place to go. And if the court knows if you're homeless and don't have any place to live, you're going to probably pick up some trespassing cases. He does have 2 prior cases where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out that I think the most, or the felony probation case was in 2000. And the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but for the fact that he already has his 2 prior theft cases, and the other felony case was bumped up to a 3rd degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003, it looks like, 23 years ago. He tells me that prior to being arrested, he was working for a church,
Yeah.
getting paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malpino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety, in my opinion. If the PSI reads as if he expressed interest in that, I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize. Mr. Johnson did want to speak to you, just so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it where she took my kids from Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But 2 things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is, it's better to work than to be doing all that. You know, it's a different way that I'm going to go by doing things this time, you know.
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be, the worst I could do today is give you 5 years in prison. If I sent you to prison,
Wow.
you'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on, you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
Well, probation.
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of property with previous convictions. find those prior convictions that you pled true to, true, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to.
Right.
If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir.
Thank you.
Thank you. No fine. Mr. Rojas, you've got Mark Newell.
I'm sorry, who just?
Newell.
Which one do you want to plead to? We're going to.
Good morning. Are you Mark Anthony Newell? And Mr. Rojas, will your client waive the formal reading of the motion?
Here we are.
Mr. Newell, in clause number 23, DCCR 0916, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 2nd of 2024 for the state jail felony offense of evading arrest or detention with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Answer out loud, please. Thank you. It alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
That's true.
Count 2 alleges that you failed to immediately report to the probation officer your address change. Is that true or not true?
Sure.
Count 3 alleges that you provided a urine sample October 29th of 2025 that tested positive for marijuana. Is that true or not true? True.
It's true.
Count 4 alleges that you provided a urine sample March 4th of 2026 that also tested positive for marijuana. Is that true or not true? Count 5 alleges that you admitted to your probation officer that you were using K2 or synthetic marijuana on March 4th of 2026. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the community service hours as required. Is that true or not true? Count 7 alleges that you're behind in your court assessed fees as of March 4th of 2026 in the amount of $2,020. Is that true or not true? Count 8 alleges that you failed to report in person to the Harris County Probation Department February 12th and February 26th of 2026. Is that true or not true? And then count 9 alleges that you failed to report to Jefferson County either online or by mail for the months of May of 2025 and then January and February of 2026. Is that true or not true? Did you enter your pleas of true to counts 1 through 9 freely and voluntarily? Did anybody force you to plead true to those counts?
I just want to get this over with.
Well, so did you plead true to those counts because they're actually true?
Yes.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
You fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number one,
No objection.
it's admitted. Is there any evidence that Mr. Newell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, I'm going to revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. You probably already received the other, but just in case, I handed you the admonishment regarding your ineligibility to possess a firearm or ammunition. So because you have a felony conviction, you're ineligible to possess a firearm or ammunition. If you have any questions about that, you can read that document or ask Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff. Thank you for being here, ma'am. Rosendo Ochoa. Sorry.
It's gonna go counts 2 through 5 on this, Judge. Count 1 is refused.
Thank you. Good morning. Are you Rosendo Ochoa? And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Ochoa, in cause number 24 DCCR 0367, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for evading arrest or detention with a motor vehicle, a 3rd-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The state has elected to proceed on counts 2 through 5. Count 2 alleges that you violated your probation by failing to avoid injurious or vicious habits by, oh, no, wrong one. I'm sorry. Count 2 alleges that you provided a urine sample on December 10th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
False.
I'm sorry.
True and false.
How's it true and false?
I did community service. I just didn't do it. I just didn't finish.
You didn't finish it. So we'll just do not true then for count 3. Count 4 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy.
False.
Count 5 alleges that you failed to pay. So you did the MRT program and finished it?
No.
So how's that false?
Oh, true.
It's true that you
It's
didn't
true.
finish.
Okay, so,
Yeah, my fault.
okay, so you did not complete the moral recognition therapy. So that would be true, that that was a violation. All right, so count 2 and count 4. Count 5 alleges that you have, are behind in your court assessed fees as of February 18th of 2026 in the amount of $500.
Yes, ma'am.
That's true. Did you enter your pleas of true to counts 2, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And obviously you understand if I follow this, then you can't change your mind later and appeal or anything like that. So it looks like the agreement that you've reached is for me to continue you on probation, order a 45-day sanction in our jail, and then you would be back on probation, and hopefully following all the rules and doing better. Is that your understanding?
Yes, ma'am.
All right, then at this time, I'm going to find that you entered your pleas of true to counts 2, 4, and 5 freely and voluntarily. Find those counts true. find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to give you this opportunity. So this is your second chance. I don't want you to think you're going to get a third, okay? I'm going to order that you serve 45 days in jail. It looks like you probably already have credit for that. You'll get credit for any time that you've been in since this arrest on the MTRP, okay? And then you'll be back out on probation. I do want some type of substance abuse assessment done based on that positive test. If there's something that probation thinks you need to do to make sure that you stay clean, you are going to be required to do whatever that is. Wear a drug patch, go to classes, be in the drop program, whatever. Do you understand? All that's meant to make sure that you do better and successfully complete this probation. You still don't have a felony conviction on your record, but you're getting closer to getting one if you keep violating. You need to get that MRT program done. I want it started within 30 days of your release from jail. So we're not going to put it off to the end of probation. I want it done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement I followed. So you did waive your right to appeal. All right. Good luck to you, sir. Take advantage of this opportunity.
They just,
Willie Pugh.
that's one we're asking for a week on.
We're just trying to get out ahead of a suppression hearing on that one. Just a quick phone call might
Okay.
alleviate a hearing. And if not, I anticipate probably going to trial due to the offer.
All right. I'll reset it to next week.
They just,
Okay, reset it. And if it's going to be dismissed due to that issue, I'll do it.
Thank you. Mr. Lane, you have Khalil Bradley Harris. You can make sure you get that email, the attachment emailed today. Okay. Good morning. You're Khalil Bradley Harris. And will your client waive the formal reading of the indictment?
And Judge, with the court's permission, we proceed on the lesser included offense of UCW. My understanding, and I included on the paperwork, that he will enter a plea of true at his parole hearing and be revoked on his parole. We're concurrent with this. And also, if I could just ask, just so that the record reflects to coincide with the previous times we've been in court, I did request Officer Champagne's video for Mr. Lane. It was up front for quite some time. I'll just like him to advise the court in the record that he did obtain that and review it for his client prior to this plea.
Okay, thank you. All right, Mr. Bradley Harris, the state has elected to proceed in cause number 25 DCCR 1334 with the lesser included offense of a Class A misdemeanor unlawful carrying a weapon. I'm just looking because y'all did state jail felony paperwork, but it's the lesser, so there's just a lot of stuff that doesn't apply on that state jail
Correct.
felony.
It needed
I
to
think-
be done with third degree paperwork.
Yeah, and then written in with the lesser. I think that's cleaner. I'm gonna delete this. Y'all need to do the paperwork on the TDC paperwork since it's a TDC crime, and then write in the lesser.
In regards to this case, except for his family,
Right.
like his mom and sister.
So, and you guys can do that. What about just where we are on the case?
I have not yet made an offer. This will give me an opportunity to meet with the family and be prepared to do that in the next setting.
Okay,
30-day reset.
Yeah, I'll do a normal reset. Make sure, Ms. French, if you can get an offer to Ms. Holmes as quickly as possible so she can go over that with her client and the family, since the case is getting, already kind of old and he's in custody. So we need to get it moving one way or the other.
Yes, ma'am.
All right, you can go back with the bailiff. This will be the last, announcement. And then you have, well, let me do this real quick.
No.
Does, do you have something on that? Do we have some here?
It was mine, Your Honor. He was waiting and they said it.
Okay, hold on. Yeah. Let's start back at the beginning and. All right, Khalil Bradley Harris. Oh, never mind, I don't have it yet. Would y'all check the tablet, please? Ms. Holmes, you've got Breanne Williams.
Yes, Your Honor.
I mean, I'm assuming.
Good morning, ma'am. You're Breanne Williams?
Yes, ma'am. So it's a bit of confusion on this one. There's a newly indicted case. However, the case was from 2024. And it's my understanding with Ms. Williams that that was addressed when the motion was filed in 2024. But the case had not been filed yet. But she was sent to Franklin House and some other treatments. And now, 2 years later, the case is filed.
It's indicted now.
Yes, it's indicted. So.
Okay, so it looks like there was a motion to revoke. Filed. No, I've got a order. Don't see the action motion from January of 25. January of last year. No, it's in for. So we need to take a look at this one. I'm missing the motion.
Okay.
There's two orders from 2025, January of 2025. But no motion, so that's, and then there was a motion. Here it is. It's probably because I did this. Never mind. There's a February 18th of 2025. She was here, pled true to counts 2, 3, and 4, and to continue probation with Franklin House count. So the count 1 was that new offense. She did not plead to that one. So what she pled true to was testing positive for marijuana, out past curfew, and behind in her fees. And so it really does not appear that it was taken into consideration, at least on that motion. Now, I don't know that if she's doing well now, that it makes sense with all this time for it to just be indicted for her to, I'm with you on that, I think. Ms. Malfino?
Judge, I don't disagree with Ms. Holmes in the court. I would ask Ms. Chopper Bradley if she has anything to add that would help us unwind this little bit of a
Well, it appears also that there is a new arrest,
for failure to
Failure to
ID.
ID.
Yes,
and so there should be,
probably
I don't know why there's not an amended motion filed. There should be an amended motion, and there's not, because there's allegation of failure to ID from October 1st of 2025. The arrest for public intoxication from October 1st of 2025. All this is in the administrative hearing dated December 2nd. So I don't, curfew, so it doesn't appear to me that the motion
Yeah.
has anything to do, honestly, with the new case. The motion is, it doesn't need to be an amended. It says what it's supposed to say. So there's a motion that was filed that says failure to ID,
right.
PI. So we've got that.
Okay.
It does not allege that new offense. We have the new offense, but the motion alleges a different
The
new
failure to ID.
offense and a public intoxication, two new items. So you guys can visit about that.
Okay.
So do you want to visit today and
Yes,
get to
ma'am.
hold it?
Yes,
Okay,
ma'am.
I'll hold it. Because obviously those give me more concern than an old one. Yeah, okay, go back with, go to the back. Just. All right, Khalil Bradley Harris, again.
Khalil Bradley here. She's now policy, I'll give it back. I'll be in jail, go ahead.
All right, we're back here. You're again Khalil Bradley Harris.
Yes, ma'am.
And this is 25 DCCR 1334. And I've already gone through with Mr. Harris his plea to the lesser included offense of a Class A misdemeanor unlawful carrying, correct?
Yes, sir.
And so, Mr. Harris, did you enter your plea of guilty to that lesser included offense freely and voluntarily? And did you plead guilty to that offense because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Bradley Harris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It's my understanding that part of this is that you are agreeing to plead true in any parole hearing, and then whatever they decide to do is what will happen. Is that your understanding as well?
Yes, ma'am.
I am going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Mr. Lewis, you've got Ephraim Dinkin.
Yes, ma'am.
It's a sentencing.
Thank you.
Good morning. Are you Efrain Dinkin?
Yes, ma'am.
And this is cause number 19-32080. And Mr. Dinkin was previously in court, entered pleas of true, and a motion to adjudicate pled true to counts 1 through 5. And the agreement was for a cap of 10 years. I've received the updated report from probation. Have you both had an opportunity to review that report?
They have Judge.
Any additions or corrections? All
No, not from the state.
right, then you may proceed, Mr. Lewis.
Judge, as far as this situation, Mr. Dinkin, moving with Mr. Dinkins, we know it's a big ask. He is asking that the court consider keeping him on probation, maybe amending his conditions.
Well, first of all, I can't continue him
Okay,
because his probation expired in 2024. So the only option would be to revoke him, sentence him to time on a straight probation. That's the only option other than regular term.
well, let me rephrase that, Judge.
Okay,
We understand that, okay, even if he is the conviction, he does take the conviction and he goes to a straight probation. What Mr. Dinkins is asking for is the opportunity to get the help through probation that's available to him. He know he is messed up and there's times that he hasn't in the past taken taking those opportunities that was available to him. He's more than willing to try to do that for us, the anger management and the things of that nature. He's trying to better himself. He's a lot older now, you know, to where he can kind of really realize where he is in life and what he wants to do with himself going forward. He knows that probation can help him. He understands that, you know, this, if given that opportunity, it would probably be only one opportunity and it'd be a zero tolerance type situation. And that's what he's asking for, Judge.
all right. Thank you, Mr. Lewis. Mr. Smith?
Judge, I would disagree. I think revocation, he had a chance at probation. He absconded. He did nothing. We have no idea what he had been doing for that time. And so I feel like PDC time is appropriate in this case. He was given a chance by his own choices. He believed that.
So, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019. So it's not like you were young and you've learned something and, you know, you were a kid when this started. You started testing positive for cocaine back in 2022. You were referred to the ATAR substance abuse program, did not comply with all of those directions. So you were given help. Then another administrative hearing was had September of 2022. You tested positive again for cocaine. Even though you had previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF and you never showed up and you've been gone ever since. So I don't know what other options or things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. All right, you can go back with the bailiff. Christopher Fair, Mr. Lewis.
Yes, ma'am.
Yes.
Good morning, sir. Are you Christopher Fair?
Yes.
This is cause number 1830684. Mr. Fair is on probation for indecency with a child, and there's a motion, a first amended motion to revoke probation. What is the announcement?
Well, Judge, a lot of the situation dealing with Mr. Fair does revolve around some incidents that happened in Walker County. We have been working to try to get that information in. It looks like we are getting some updates as far as those charges. And on our end, Judge, I would need to ask for a little time just to see exactly where they are. They haven't been indicted for the felony cases. There were basically 2 felonies, 2 misdemeanors. The misdemeanor cases, I do have gotten some information on. I have received confirmation that they were accepted as far as the felony cases, just have not been indicted yet to know exactly what was going on. Right.
The cases have been accepted, but not yet indicted. And those were felonies that were pending from the same incident.
Okay. So it looks like, at least in the motion, we've got a possession of marijuana. We've got an unlawful possession of a firearm by a felon. We've got a possession of drug paraphernalia.
I got a government chip in my knee. Defendant's insane courtroom meltdown stuns judge. A Texas courtroom turned completely chaotic when a defendant interrupted his own competency hearing with bizarre claims about government mind control, hidden chips, and voices in his head. The man was already being evaluated on multiple criminal cases when the judge reviewed a psychiatric report declaring him mentally incompetent to stand trial. But before the hearing could even finish, the defendant suddenly exploded into a rambling outburst that left the courtroom speechless. He shouted that the government had implanted a microphone chip inside his knee, claimed people were manipulating him through phone applications, and admitted he hears voices in his head. He also insisted he refused to take medication because authorities were trying to control him. The judge tried to calm him down, but the defendant kept talking over the court, bringing up past shootings, robberies, and conspiracy claims while demanding probation and immediate release from jail. After the disturbing meltdown, the judge officially ruled that the defendant was not competent to stand trial and ordered him sent to a state mental health facility for competency restoration treatment.